look at the actions your office investigated when it comes to Dr. Farley, former Dr. Farley, do you feel like it exposes a gap in Oregon's law?
Of course it does, yes. And that was the research that my prosecutors came up with as well.
Tonight, a KATU investigation into Oregon law and the possible free pass from criminal charges some doctors may have, even in cases of misconduct. The loophole may be one reason a former West Linn doctor accused of abusing over 100 former patients has not faced criminal charges. Thanks for joining us for KATU News at 6, everybody. I'm Steve Dunn.
And I'm Deborah Knapp. KATU investigator Wright Gazaway joins us with another development in this investigation, right?
David Farley will never legally practice medicine in Oregon again. Some of his former patients say that's not good enough. They want him in prison. However, the Clackamas County District Attorney says state law prevents that.
I can't go to bed at night knowing that he is out there.
Nicole Snow, Katie Medley, and Lisa Pratt still find it hard to believe their former doctor, David Farley, does not face criminal charges
for chronic neuropathic pain.
This is video of Farley from an unrelated story KATU did in 2016.
There's a pattern, and so I don't understand why they don't want to be on the right side of history here. You believe people, you help women, you don't just let doctors get a free pass because they're a doctor.
The Oregon Medical Board revoked Farley's medical license in 2020. It found Farley took nude pictures of minor patients and told parents those pictures were for a medical study. The medical board called that study unethical. Farley says he got consent but could never provide proof to the medical board. The board also found at least 3 cases of Farley performing unnecessary pelvic exams and pap smears on minor patients. Farley agreed to a lifetime ban from practicing medicine in Oregon. Despite those findings, a Clackamas County grand jury declined criminal charges in September 2022. The medical board's findings detail misconduct involving minor patients. These women say he did many of the same things to them. They say they took Farley's word that those procedures were necessary.
What's so hard to me is when you go into an office like that to somebody who's trusted in a community like a doctor, somebody who's such a high standing position, you trust them, right? We're going in, you don't ever expect to be abused. There's a huge layer of implicit trust there when you walk into a doctor's office.
I was lied to. I was lied to about my needing to even be in an appointment during which I was sexually assaulted. I didn't consent. That's not informed consent.
Remember that the system is designed to protect those who are accused.
Clackamas County District Attorney John Wentworth won't share the full list of charges his office or the grand jury considered. However, many laws in Oregon related to alleged sexual assault say a person is unable to give consent if they are, quote, physically helpless. State law says a person is physically helpless when, quote, a person is unconscious or for any other reason physically unable to communicate unwillingness to enact.
These women are saying, we're not doctors. We don't know that we don't need this procedure. He's telling us we do. We'll take his word for it. Other states have interpreted that physically helpless, unconscious state as people not knowing better, not necessarily being asleep or unconscious in the literal sense. Did your office consider that these women are not professionals, therefore they can't really consent to behavior that they don't know anything about?
Well, we don't have any case law to suggest that ignorance or misdirection makes a person physically helpless. That's what you're asking. There's no case law to support that. The statute doesn't support that. That's a challenge within the criminal law.
In Oregon.
In Oregon.
Specifically.
Wentworth says existing state laws make it too hard to prosecute Farley. A previous KATU News investigation outlined an exception in Oregon law for the crime of unlawful penetration if it is, quote, part of a medically recognized treatment or diagnostic procedure. It does not say anything about that procedure being medically necessary. Wentworth says that was a challenge when they looked at criminal charges for Farley's pelvic exams that the medical board outlined.
The procedure itself is a medically recognized procedure. Whether or not it's a recommended procedure is a different issue.
So in other words, since a pelvic exam is recognizable, if someone does that 12 times a year, even though you're not supposed to, because the other 11 times he does it for gratification or for whatever purposes, That, in your mind, is not criminal behavior.
Was not my mind. Remember, we presented this evidence to the grand jury.
The legal situation is different for doctors in other states. In Michigan, for example, where former Olympic doctor Larry Nassar pleaded guilty to criminal sexual conduct, the law goes much further.
It says when the actor engages in the medical treatment or examination of the victim in a manner or for purposes that are medically recognized as unethical or unacceptable, the person is guilty of sexual battery. Would you like to see Oregon Code be that explicit for prosecutors?
That would have made this case much easier.
Similarly, California law criminalizes actions by a doctor if doctors lie to their patients about a procedure being necessary. I read that law to Wentworth.
Any person who touches an intimate part of another person for the purpose of sexual arousal, sexual gratification, or sexual abuse, and the victim is at the time unconscious of the nature of the act because the perpetrator fraudulently represented that the touching served a professional purpose, is guilty of sexual battery. If that was the code in Oregon, do you believe there would be a crime here?
I don't want to speculate on that because you have to develop that entire level of case law and understand legislative intent. I believe it would make it easier, though.
So you would like to see the Oregon Code be that explicit?
That would be wonderful.
I mean, when you look at the actions your office investigated when it comes to Dr. Farley, former Dr. Farley, do you feel like it exposes a gap in Oregon's law?
Of course it does, yes. That was the research that my prosecutors came up with as well.
It's up to the Oregon legislature to more clearly define the law and close the gap Wentworth points to. Wentworth says he'll ask lawmakers to do so in the 2023 legislative session, which starts in mid-January.
If it happened to us, it's going to happen to anyone.
However, some of Farley's former patients and their attorneys say the facts warrant criminal charges now under current Oregon law. They want Attorney General Ellen Rosenblum to take the case on.
We know it's really hard for the Attorney General to take this on. It's really difficult. And the Department of Justice, but it's so important. It's so important. And we know that they can do it.
Every time that we have a chance to really explain the things that Farley did, people are very confused why the police didn't take action.
We can only hope that someone will step up and do the right thing and help us to put this man behind bars, because that's what we need. That's what needs to happen.
The Attorney General's office says it is still reviewing that request. Her office has not made a decision. Wentworth says he will reopen the case if more evidence is presented.
So, what does Dr. Farley have to say about the women's accusations?
I reached out to David Farley's attorney of record on numerous occasions via email and phone. We have yet to hear back. The only response so far in a civil lawsuit against him is a request by his attorneys to delay that case until the criminal investigation was over.
An Oregon lawmaker wants to close the legal loophole that allows doctors to lie to their patients and sexually abuse them.
Earlier this year, a KATU News investigation revealed the gap in state law. A bill is now making its way through the legislature that would change the law to protect patients instead of doctors.
The gap is basically an error in law.
State Senator Mark Meek wants to close a gap in Oregon law that makes it too hard to prosecute doctors.
Unfortunately, they have immunity, yes, and I think they are above the law, and that's why this bill this year is very important to eliminate that gap.
The legislation follows a KATU News investigation that found state law prevents charges for sexual abuse if penetration is, quote, part of a medically recognized treatment or diagnostic procedure. In other words, right now, doctors are protected if they lie to patients and give an unnecessary pelvic exam.
It's frightening and disgusting.
Katie Medley says that's what her doctor did. She told us this last year.
I was lied to. I was lied to about my needing to even be in an appointment during which I was sexually assaulted. I didn't consent. That's not informed consent.
We presented much of the evidence the Oregon Medical Board relied upon to the grand jury.
Clackamas County District Attorney John Wentworth says a grand jury could not bring charges against Medley's doctor, David Farley, due to shortcomings in Oregon law.
Unfortunately, it's been a loophole and provides immunity for those certain, providers that utilize this for their own gratification. And so it's very important that we fix and close this gap.
But the proposal brings Oregon in line with other states. Our investigation uncovered that California law criminalizes actions by a doctor if doctors lie to their patients about a procedure being necessary.
Would you like to see Oregon Code be that explicit?
Yes, of course. I think that would be a wise addition to the criminal code.
That's what Wentworth told me in December 2022. The DA asked me to fix the issue in the current law.
I figured this was a time we needed to address this.
Senate Bill 974 makes it a crime to lie to a patient and touch them for sexual gratification, just like that California law.
We're creating a new felony by this process, but I think it's important to make sure that these medical providers are held accountable and understand that this is not a loophole any longer available to them.
Meek hopes that's a message the entire Oregon legislature sends this session.
Meek anticipates a public hearing on the bill in the next couple of weeks. He believes it will pass this session. So far, he says no one has come out to oppose the bill. He says doctors who follow the law should support the change and not worry about being prosecuted for doing their job. David Farley and his attorneys have not responded to any of our requests for comment.
The gap in Oregon law related to doctors sexually abusing their patients is closed. Senate Bill 974 unanimously passed the House this week. Heads to Governor Kotek's desk. It makes it a crime for doctors to lie to their patients and then sexually assault them. Previously, Oregon's sex abuse law provided an exemption for medical care. The case of West Linn Dr. David Farley sparked the law. More than 100 former patients accuse him of sexually assaulting them under the guise of medical care. He lost his medical license but was not criminally charged. A KATU investigation uncovered a gap in Oregon law compared to other states like California. Here's Representative Lisa Reynolds shortly before the law passed.
And while we can't predict what would have been the outcome on this specific case described if the bill had been law at the time, the case shines a light on the gap in Oregon's criminal code, and Senate Bill 974 helps close that gap.